Rachel Barkow is a law professor and nationally recognized expert on criminal justice reform. Her most recent book explores how law enforcement, prosecutors, and prisons came to play such an outsized role in the criminal legal system. Rather than assigning blame solely to legislative or executive bodies, she points a finger at a surprising culprit, the very institution meant to protect fundamental rights and liberties. From the Drug Enforcement and Policy Center at The Ohio State University, this is Drugs on the Docket. Each episode will tell the story of how U.S. court decisions impact drug law and policy and continue to shape the war on drugs. I'm your host, Hannah Miller. Today, we discuss the United States Supreme Court and how some of its decisions departed from long-standing judicial interpretations concerning individual rights and the criminal justice system and paved the way for mass incarceration. If you like what you hear in today's episode, visit go.osu.edu/drugs on the docket to follow the series.
Rachel, we're just so excited to have you here to talk about your amazing new book, Justice Abandoned.
Oh, thanks. And thanks again for having me.
You lay the chapters out in a particular order. You clearly have a just brilliant structure for how you sort of thought through and executed this accounting of the Supreme Court's work in a variety of criminal justice areas. I'd love to have you talk us through that, give a little background on your book and how you came to this project. And then, maybe even, I don't want to quite say regrets, but I suspect there were maybe some other cases and some other issues that made the book cutting room floor. So if you want to talk about that too, that would be great.
It's almost a sequel to the book I wrote a couple years ago, which was really about the politics of mass incarceration. Because, I do think the way America gets to be the world's leading incarcerator is through political dynamics here and the way they operate. But when I was writing that book and I got to the end, I wanted to say some possible avenues for reform. And one of them was court challenges. And as I was writing that chapter, I started thinking about, they haven't been very successful, but maybe they haven't been very successful because the judges are former prosecutors, government lawyer types, and we need more diversity on the bench. But as I was thinking through that chapter, it just kept gnawing at me that, gosh, there's just so many constitutional provisions that are designed to check against these political dysfunctions, and we just have not had that happen. And so that's how this book came about, is I wanted to look at the Supreme Court's decisions in these key cases where the court, in my opinion, got the cases wrong, and how important that had been for allowing the politics to run amok. So, and when I say, in my opinion, got the cases wrong, I should actually say, I use the traditional methods of constitutional interpretation. So they're not just cases I disagree with. That would be, the multi-volume encyclopedia set of, cases Rachel doesn't like would fill your whole bookshelf. But this is a series of cases that, if you look at the Constitution's text, if you look at its original meaning, if you look at precedent at the time the case was decided, these cases fail those major constitutional theories of interpretation. And the cases themselves, in addition to being wrongly decided, had to be cases that are critical for mass incarceration. So chapter 1 is about a case that involves pretrial detention. As you know, and I'm sure many of your listeners do, pretrial detention is almost a quarter of the number of people who are incarcerated in America. It's over 400,000 people on any given day are there, having never been proven guilty of anything. They're supposed to be presumed innocent. So the first chapter deals with the case that really allowed that kind of huge uptake in the number of people pretrial. The second chapter deals with a case that involves plea bargaining, which, I believe is the engine of mass incarceration, because you just have to have mass case processing in order for that to function. And, this is a case that really allows a coercive prosecutorial, I don't even want to call it a bargain, really threat, and says it's fine. And so plea bargaining is chapter 2. And then the third chapter deals with the Supreme Court's failure to give any bite to the Eighth Amendment's cruel and unusual punishment oversight, looking at sentences for being disproportionate. So, I look at those three as really the core, because they're really dealing with the mass case processing. So you're admitting more people, you're putting them in jails right away with pretrial detention, and there's really no limit on how long they stay. stay. That's the recipe for mass incarceration. Then the last 3 chapters are indirect, but in my mind still really important. So one of them deals with prison conditions and overcrowding, because when you think about a jurisdiction being able to incarcerate people, I view it as like a 2-for-1 or sometimes a 3-for-1 sale, because you can triple bunk people in spaces that were designed for one human being to mentally and physically be okay. Jurisdictions now start cramming 2-3 people in those spaces, and they should have been held unconstitutional. The court blinks, doesn't do it. And so what you end up having again is a way to really ramp up the number of people incarcerated. Then one of them deals with policing. I do Terry versus Ohio in the book because I think changing the standard for stop and frisk really led to mass policing in America in urban environments. Because if you're stopping tons of people, you're feeding the pipeline. And then the last case that I talk about is McCleskey, which is a racial discrimination case in the criminal justice context. I think that's also crucial for thinking about mass incarceration, because I don't think we would have the numbers of people we do in America if it wasn't disproportionately falling on communities of color. And so I think it's important to consider how the Supreme Court makes it almost impossible to make a claim of racial bias when it comes to anything, really anything, but also anything related to criminal justice. So that's the framework. And, together, I think they tell this story about how there's really no brakes on the politics of mass incarceration, even though our framers put them in there. They wanted there to be these important constitutional checks, and we just really haven't had a court willing to buck up and actually enforce them.
I've listened to other interviews that you've done on this book, that you took a slightly different approach with this book's message compared to your previous publication. So could you elaborate a little bit on how this book's message differs from previous works?
Yeah, so I think it's important for the Supreme Court to start getting some of the blame. I think we all understand how politicians have fed into this, how community fears have fed into this, how the media has fed into this. But I actually haven't seen much, if anything, on the Supreme Court as a really key enabler. And so, one, I wanted to just show people that it didn't have to look like this. And one of the reasons that it does is because the Supreme Court failed at its task. And then the second reason is I do think, I'm not saying I would bet money on this, but I do think it also presents a possible avenue for reform that is a little bit different. Because, if the sole cause of mass incarceration, excessive drug policy is all politics, then, we all have to work in the political sphere and think about changing it. But if it turns out that there are constitutional provisions that are just not being properly interpreted and enforced, that suggests a different avenue. Then that suggests that maybe people who care about these issues need to really start focusing on judicial appointments. In the same way that abortion advocates, pro and con, have known for decades that Supreme Court seats really matter, right? They're in those fights. They're like asking, what was your position on Roe? I would like people who care about criminal justice to say, what? Criminal justice issues are also really important issues that the court decides. And so if you care about those issues, you've got to care about who gets appointed to the Supreme Court. And so it's a way to engage with possible reform measures that would have advocates and people focusing on, in addition to all their grassroots organizing and all that, it's not mutually exclusive at all. But it is to say, let's add the Supreme Court and judicial appointments to the mix, including lower courts, because there is a lot of really good constitutional protections out there just for the taking. If we could get the right people on the bench who see this and are, have the courage to actually do what they're supposed to.
All of these judges seem to be really insulated from public ire, and they're also insulated from the politics of the time, right? How do we actually combat any type of appointment that would be detrimental to criminal justice?
Yeah, no, it's a great question. And unfortunately, it is a tough one. You pay attention to who's getting appointed to your state high court because it really does matter who's on there. And if you have a prosecutor and you look at how they prosecuted cases and it looks like they have no understanding of the kind of other side, that's not a great appointment. And then at the federal level, that's the toughest one, right? Because, you're really thinking about who you're electing as president. What kind of people is this presidential candidate going to appoint? And, one thing you can do is in the primaries of your party is try to push to get people that are going to commit to appointing certain kind of people. We need professional diversity on the federal bench because it's filled with former prosecutors. It's like almost half of all federal judges were former prosecutors, which is bonkers, right? That's an insane mix. You can have some, but it shouldn't really be that many. We really need to get people who have represented individuals in the criminal justice process, criminal defense lawyers, civil rights lawyers, people who have dealt with individuals as opposed to coming in all the time. I represent the government. Because when you represent the government, you actually don't really meet a whole lot of people. You don't really get to know them. You don't know their backstories. But if you're a criminal defense lawyer, you sure do. You understand how hard it was for them to get the bus pass that made them go meet with their parole officer. You just get things. President Biden actually did a very good job to make sure professional diversity was a big part of what he was looking at in the bench. If you look around the country, a lot of his judicial appointments are people with criminal defense experience and civil rights. Pay attention. If a vacancy opens up, you can definitely vocally speak out that this is an issue you care about. And my hope is that some of the criminal justice advocacy groups will start seeing that as part of the agenda that they need to take on too. Every time a nominee comes up, to just say, okay, let's take a look at what their background is on this. Do we want to support it or not?
Too often, progressive groups have made criminal justice reform a lesser concern than a range of others. And so whether it's looking at particular politicians, whether it's looking at particular judicial nominees, we'll get to looking at their criminal justice record after we look at what they're saying about women's rights or racial justice issues that aren't related to the criminal justice system.
My other hope is that in addition to people who care about criminal justice, we get the racial justice groups to do it too. Because I think of all criminal justice issues as racial justice issues. And so my hope is that they would also be just really adamant that these appointments need to be people who understand those issues.
I think you've given a really great blueprint for how, from a grassroots level, someone could be a bit more cognizant of what's going on.
You do a terrific job, Rachel, throughout the book, highlighting the interplay between the work of the court and individual justices, the broader political realities that are going on at the time. But I don't think it's a coincidence that all your cases come after 68 and the war on drugs started. And I'm eager to hear you talk a little bit about kind of how you see those things fitting together. Most of the cases aren't actually drug cases, but I just like to get your sense more generally on, how the war on drugs, the war on crime, the range of tough on crime political stories, which was very much a part of your first book, you think shapes some of the stories and the decisions that you're emphasizing in this book.
It's an important thing to highlight, I think. They are all kind of tied together that way. I view the campaign season that brought us Richard Nixon as kind of the key beginning of all of this. Because in the 1968 presidential election, you had Richard Nixon and George Wallace both running campaigns that heavily criticized the Supreme Court for prior decisions upholding criminal defendants' rights. So, two in particular, the Miranda case, where people know you get read your rights when you're being interrogated by the police, and Mapp versus Ohio, which was the case that excludes evidence that has been obtained unconstitutionally, which a lot of people say, that lets guilty people go free on technicalities. Not politically popular cases in the 1960s, for sure. There are literally impeach Earl Warren signs on people's lawns. So he was the Chief Justice. So if you can imagine, impeach John Roberts signs being part of a major campaign today, it was a big deal. And the justices knew it. And at a time of rising crime rate in America, you do have an uptick in homicide rates at the end of the 1960s. Tons of unrest, right? People are protesting all over the place. The Vietnam War, they're protesting racial injustice. A lot of those protests turn violent and into, there's riots, there's fires, cities are burning. There's 2 political assassinations. It is chaos in America in 1968. And so Richard Nixon, who ultimately wins that election, is running on a law and order platform. And he's not the first to do it. Barry Goldwater had tried that as well. Ronald Reagan, in running for governor, some House seats ran on this. But, this is the big presidential win on the basis of a law and order campaign where he says, he is going to bring back order to our streets. And that includes, by the way, there's tons of drug use now in America. You got a lot of people who are coming back from the Vietnam War. The drug problem is kind of everywhere on college campuses. So it looks to Americans, your kind of average American voter, like we have a big problem with drug use. We have a big problem with violence. We have a big problem with unrest. And Richard Nixon comes in and he says, I'm the candidate to bring order to all this. And, part of the problem has been our Supreme Court and these crazy cases that, have hamstrung our police. So in that presidential election year, Terry versus Ohio, the policing case I talk about, is decided as the campaign season is going on. And in the justices' papers, it's pretty obvious that they are sensitive to the fact that they do not want a third case to become part of the presidential campaign, right? They've had enough. So when they vote in Terry versus Ohio, they don't even really stop to think about it. They kind of just reflexively say, we've got to allow officers to stop and frisk people on something less than probable cause. It's just such a results-oriented decision. It's just painfully obvious. The other thing that happens in 1968, Richard Nixon does get elected. So first of all, he's going to fill a bunch of Supreme Court vacancies. That's going to sort of set the stage for what is going to be a conservative majority on the Supreme Court thereafter. But the other thing he does is he realizes, if you're president and you run on this, like, I'm going to make America not chaotic anymore when it comes to crime, that's a local problem. That is a heavy lift for a president. So what he decides he's going to do is he's going to focus on the District of Columbia. And he gets this lawyer in his administration, William Rehnquist, who is going to become the Chief Justice. He gets him to help draft a law for the District of Columbia that will allow people to be detained pre-trial after they've been arrested, even though they're presumed innocent, if the government makes a showing that they present a danger. And it's the first time in 200 years anybody ever, no one had tried to do that, because the settled conventional wisdom was, of course you can't do that to someone who's presumed innocent. That's what the trial is for. You could detain someone because they're a flight risk or because they're going to tamper with evidence, but you don't get to detain them because you say, yeah, well, we really think that they did it. And that thing they did was dangerous. So no one thought that was okay. But Nixon has this idea that if we can get a law like that in DC, that'll be the seed that will then let it spread all around the country. And he's right. That actually does end up succeeding, right? And so he has Rehnquist write this DC law, which is very narrow. It's got a 60-day cap on the number of days you can be detained. It's very hard for the government to make the case that someone is dangerous. That, over time, morphs into the federal bail law that's passed in 1984. In the law itself, presumes dangerousness if you are charged with certain drug offenses. And it's drug offenses that have a statutory maximum of 10 years or more, which is almost every federal drug crime. So it basically means every federal drug offender is presumed dangerous under this law and should be detained pretrial under it, unless they can overcome the presumption. And frankly, most judges around the country don't even bother. They don't even look. It's like a rubber stamp. And that's how you get 75% of all federal defendants detained pretrial. Most of the people being detained in the federal system are there for drug offenses. Those two cases are directly tied to 1968 and that kind of beginning Nixon era. But the rest are too, because Nixon puts in place these justices who have this very law and order perspective. And so as cases get decided, you see that in kind of, they're just very deferential to the government. They just want to make it easy for the government to do what the government claims it needs to. So when you get to a case like Harmelin, which is a case involving Eighth Amendment oversight of of life sentences for drugs, the Supreme Court basically has a view that, well, if the government has any reason for wanting that punishment, then it's fine. The briefs that the government files and the amicus file in that case are basically all about how, there's no worse crime than drugs. It's really the court aiding and abetting the drug war by allowing the government to do what it says it needs to do.
I think one huge problem that an awful lot of folks now looking at Harmelin and thinking about the development of Eighth Amendment jurisprudence is, wow, they upheld an LWOP sentence, life without parole sentence, for a first-time drug offender. And we all know that's the least serious offender. Well, that wasn't their thinking. It certainly wasn't Justice Kennedy's thinking back in 1991. For them, somebody with a large amount of drugs was one of the most serious offenders. And the William Rehnquist story is just so fascinating that I didn't even know and should have known, for just how the bail stuff, grows out of very much that era. But really, from a sort of drug war perspective, even though the foundation was laid in the Nixon years, it really kicked up to a whole new level in the 80s and early 90s. And I think that's one of the things that both makes the Harmelin case so notable, being a 1991 decision, but especially because, as you highlight in your chapter, there are actually some more positive, or at least more involved rulings about Eighth Amendment limits on extreme sentences that were kind of competing for attention, you might say, in the 80s. And we've now, I think, evolved, the politics have evolved. We think of drug offenses as not as serious an offense, but that still stands as a precedent that's hard for lower courts to think about moving away from. I think the Hutto case, where the court upholds a 40-year sentence for, I think, a second-time marijuana offender, and the sense is, well, wow, we know marijuana is nothing serious at all, and the court upheld that. Well, in the 80s, that wasn't their thinking at all. And so it's just being sensitive to those cultural differences.
All of these cases indicate a power shift, just really eroding one's constitutional rights. But which of these power shifts do you think is the most consequential?
I guess I would say it's giving so much power to law enforcement, so both police and prosecutors, because I think the effect of these cases is to make it so that they operate almost unchecked. They're just very few limits on what law enforcement can do. And as a result of that, I think you really do get a very robust police and prosecutor, not just in terms of kind of what they're able to do to individuals, but as a lobbying force. They really start to emerge as politically important actors. I'm not saying that the Supreme Court is the reason they have so much power, but I think they're part of it. I think it's part of the way the Supreme Court talks about law enforcement and prosecutors is like so deferential and, almost superhero-like in what they're doing to protect all of us. And I think it does just feed into a narrative, a cultural narrative that I think also helps those folks feel very strong when they're in the political process as well. So, I think it's all tied together. I don't think prosecutors before the 1960s were a big part of the political lobbying force in America, but they become that. And, one of the reasons that they do become that is because if the Supreme Court sanctions plea bargaining, which it does, and says to prosecutors, you can threaten whatever you want as long as it's like a lawful sentence on the books and you have evidence to support that charge, that's it. You can think from a prosecutor's perspective, they're going to say, oh my gosh, we got to get more of those laws then. like, please give us a menu of those things we can use all the time to coerce people. So they go in and they do start asking their legislative branches, state legislatures, Congress at the federal level, hey, can we get some more mandatory minimums? Hey, can you raise the sentence for this? Because when you do it, it's going to allow me as the prosecutor to get more people to plead guilty, to cooperate with me. It's going to be really helpful for law enforcement. So, that's the story they're telling. And that's right. It does get people to cooperate and plead guilty. And they start then really taking a huge role in what laws themselves look like. And remember now with the Eighth Amendment, not policing length of sentences, it's not like courts are going to come in on the back end and say, yeah, you asked for that mandatory life sentence for the drug offense. That's too much. It won't be. So they lobby for it. They get it. They threaten people with it. People are going to plead guilty in those circumstances. And so I do think it's that shift in power is probably the biggest one. I guess the other one I'll say is maybe the supporting actor category is taking power away from lower court judges. Because the other thing that the Supreme Court does in these cases is they're very clearly distrustful of allowing lower court judges to police some lines. So unless they come up with a bright line rule that would hold lower court judges in check, they just take them out of the business of oversight. So I'd say those are the two shifts that I think are the big ones.
I think that's such a profoundly important point to not lose sight of. And again, it gets in, as I see it, to the sort of waves of judicial involvement in the criminal justice system. Because I think beyond the criticism of the Warren Court kind of on the substance, right? That you're letting criminals out and, stopping the death penalty and doing all sorts of things that the people don't want done for the benefit of criminals. I think from a kind of institutional perspective, especially for a number of the more conservative modern justices, that court was problematic for just sort of inventing rules that look like policy. And Miranda is a good example of that, where it's like, where's all this language in the Constitution? You're just writing stuff, and then we get not just institutional concern about sort of courts as rule makers, policymakers, lawmakers that is easy to rhetoric against, but also the Supreme Court itself has to keep getting involved in which of this rule was right and how do the Miranda warnings actually work. And Terry, they've spent years and years and years having follow-up cases to figure out what reasonable suspicion means and where it applies and all of its court-concocted nuances. But I think the most obvious example of this, the most express example of this comes in McCleskey, where the court specifically says, we can't police racial injustice in the death penalty because then you want us to police it in other areas of sentencing, and then you want us to police gender disparity. And this actually led to one of the great dissent lines of all time from Justice Brennan. It sounds like the majority is concerned about too much justice. And I think that's a fair criticism, but I think it's got to be combined with we're not confident as a court, or maybe we're just not willing to do the work as a court to invent those lines and police them when, again, against the backdrop of in the 70s and 80s, we have rising crime. We have politicians saying, the court's keeping us from using all the tools that we might want to use to deal with these crime problems. And so I just think that's so valuable to keep in mind that it's an institutional competency concern, even though, as we see in a variety of other settings, the court has been willing to make its own rules when it thinks it's worth doing it. And I guess that's a long-winded segue into where we are now, because I would say in our current era of judicial politics, the concern about activist judges is largely gone. We have a current Supreme Court that seems very open to rewriting doctrine, rewriting lines, rethinking old precedents when they don't think it fits with their vision of proper constitutional rules of the road. And so are you hopeful that you'll get to write a sequel that will talk about how they sensibly reconsidered at least some of these doctrines? Is there one area you think's most ripe, either politically or jurisprudentially, for getting reconsidered?
Yeah, so I mean, I don't think I'll be alive to write the
Oh, yeah, you will. You're living forever.
And this is no easy task to get things reconsidered that people accept as fundamental. You really have to do a lot of work for it. But I do think it's possible. I really went out of my way to pick the cases that fail an originalist test of constitutional interpretation. The only one that's a little bit less clear cut on that score is McCluskey. But the others, if you had really avowed originalists and looked closely at these questions, I think they may have even come out differently at the time. And so I do think there's some of these cases have a real shot because you do have people like Justice Gorsuch, who takes a very principled originalist approach, even if it's a criminal case that's going to result in being in favor of defendants. He's done that. And so I think it's possible to think about how you could get 5 votes even on this court for some of these cases. And as you mentioned, they are overruling stuff. They're not a big, stare decisis court. And so I clerked for Justice Scalia. And one of the things that he used to always emphasize on his speaking junket when he would be criticized as a results-oriented conservative justice, he'd be like, I voted to uphold the right of people to burn the flag under the First Amendment. And I don't think he liked the outcome in that case, but I do think he liked the fact that he could trot that out and let people know. Of course, he doesn't like flag burning. Mrs. Scalia, he told the story. When he came home from that decision, glowered at him and was like, the flag, Nino, and he would tell it with dramatic flair. And the idea was, oh, here's this poor guy had to vote against his own beliefs because he's so committed to originalism. And one of the things I think the current justices lack, they don't have a case like that. They have nothing on their speaking tour. It's like, oh, I just so happen to also believe in gun rights. And, and hey, I don't like independent agencies. So when they vote those down, everything will line up perfectly with their conservative ideology. But these cases would present a real opportunity for them to say, look, you think I want to let people be released after they've been arrested? But our Constitution is clear. You cannot detain someone just because you claim they're a danger because they've been arrested. And so I do think there's an opportunity here that would present itself if there's a good litigation strategy behind it. I tend to think pretrial detention is the best one because I think there's a lot of litigation around the country right now rethinking bail and pretrial detention. So there's good political advocacy around the issue. And one of the things that I think can be done is, as courts are thinking about this, is educating them. I am actually working with some folks to try to craft an amicus brief to just let judges know, just so you know, it wasn't always like this in America. In fact, Salerno itself is wrong. Here's the backdrop, which might make them feel more comfortable putting some limits on pretrial detention. And maybe eventually what that means is there's a litigation strategy around bringing more cases to the court, because people have tried to get cert granted in some pretty egregious pretrial detention cases, and the court has just denied it. Salerno was like it. They decided Salerno and then they got out of the business. And so what I think would be good is to bring the court back into the business in the same way kind of that it happened with Roe, right? They didn't just immediately strike down the right to an abortion. They started limiting it further and further and further, and then they get to Dobbs. And I think you could have a similar strategy with pretrial detention. Maybe you start putting a cap on the number of days that someone could be detained or the conditions that they're in, or, maybe you're thinking about what the government has to prove to get that detention. So there's ways you could start narrowing it around the edges until you bring the hopefully final blow that says you just can't do this for dangerousness. So I think that's a promising area. I do think the Eighth Amendment is one. Justice Scalia was on the court when Harmelin was decided and engaged in some really terrible originalist inquiry about what the Eighth Amendment does. It's shoddy. There was no briefing. And so he did like a kind of back of the envelope. Well, there's this one case that seems to suggest, and he got it all wrong. I think John Stiniford and others have really highlighted that it's just wrong. His view of the Eighth Amendment, there's no kind of sugarcoating it. And so I do think if the justices kind of revisit the Eighth Amendment in a serious way, they'll see they have to do a lot more than what they have. So I think it's just getting it on their radar and figuring out strategically how to do it. But so I think it's a very long-term project, which is why I don't think I'll still be around for it. But I think it's possible. I really do. And I think it's particularly possible if we do get more justices with, again, more life experience, professional diversity background, where they understand the human costs of these kinds of decisions. Because I think the other kind of key thing in all of this, in addition to not wanting to give this to lower courts and whatnot, is I just think that this was a product of justices who really trusted government, like really trusted law enforcement, really trusted prosecutors, kind of just thought, well, of course, they're never going to do anything bad. They're the good guys and they are in the public interest. I don't think they're bad guys, but, I think they're human. And I think it's really important to have justices who get that, and that incentives and cognitive biases affect law enforcement like everybody else. And so you do need to have checks on that. And I think the more we get justices with that outlook, I'm also optimistic that things could shift.
What role do law schools have to play in this long-term strategy? It's just the reality of going to law school that you don't learn much about the impact of a criminal record on an individual, whether you are interested in being a public defender or interested in becoming a prosecutor. It's just an area that isn't explored much.
Yeah, I think those kinds of direct experiences are fantastic for everyone, for law students, for lawyers, for politicians, for judges. I think the closer you get to any issue and problem, the better you understand it. We've had people at NYU, we've had students who also have worked on clemency and record relief. And I think it really gives them a really great perspective on the consequences of these actions, even beyond the long prison sentences. And, again, I encourage students to visit prisons and jails too, because I think everything is so abstract and removed. I mean, many people have close relatives and friends, so they do have personal experience with it. But if you don't, I think it's really important for people to go to prisons, to go to jail, see what the environment looks like there, to talk to people who have been involved in aspects of criminal justice to find out what it means to have that involvement. What does it mean to have a record? What does it mean to have pretrial detention? You talk to someone very quickly, you realize it's going to mean someone's going to lose their job. They're going to get evicted. They're going to lose custody of their kids if there's no really easy way to place them. So their life's going to spiral out of control, even if they're only detained for a couple days. You got people who are living on the margins, and you're going to force them into a jail. No employer's going to keep them. That is really rare. They get fired right off the bat, if they have a job, and then you're evicted because you can't make your rent. You can really see pretty quickly how this is not an abstract thing, pretrial detention. The intuition for people is that, of course, it makes us safer. We lock up people who do bad things right away, we're going to all be safer. And I think when you actually have personal experience with people who are detained pretrial, you realize really quickly, oh my gosh, this policy is terrible. If we want people to not commit crimes, why would we get them fired? Why would we get them to lose their kids and their housing and just upend their lives? That's an insane policy. It's one thing to do it for people who are truly uncontrollably dangerous, but we have a commitment scheme for that. We have civil commitment for people who are in that position. But what we have done is just use criminal justice as this rubber stamp, detain, and it makes it more likely people are going to commit crimes. And I think when students get exposure to that, they get it. They get it almost immediately. I have taken my students to prisons, and as soon as they see the space, you just need to see the space, and you realize this is not setting people up for great outcomes when they come back out again. These are facilities that are going to make it really hard for people, in fact, to adjust when they're released because they're in closed spaces. You can see how there's a lot of people with noticeable mental health issues that are not being treated. And so you're in an environment that's very combustible. People learn that they have to defend themselves and they react violently to things. You see it with your own eyes very, very quickly. And so I think the law schools can give students direct exposure to things as much as possible. Clinics are great, but even talking about it in classes, I think, can also be really helpful. You can bring in guest speakers, just have people from a variety of perspectives talk about the different, just so students see all sides. And, I should say it's really important to see all sides because I don't diminish crime is a problem. Crime is a problem. What victims go through is a problem. So, it's a question of making sure we have the whole picture. And I think all of that needs to be presented. And I think there may be a tendency for students maybe to come in, maybe proportionately speaking, with a bit more understanding about what it means to be victimized by crime, because I think a lot of people just intuitively worry about being a victim of crime. If you're walking late at night, particularly as a woman in certain areas, you're thinking about crime right off the bat, right? And so, but I think what people don't intuitively think about as much, again, depending on background and experience though, is, will I be charged with a crime? What would it be if I was charged with a crime? What would the process look like for me? And so I think the important thing for law schools is to make sure that people think about it from all the perspectives, really think about it so that when we think as a society how we want to deal with things, we're not leaving out huge parts of the equation.
And I'm going to jump in to link the last two answers. And thanks for that terrific accounting and great question, Hannah, to prompt it. But I think law schools also have an obligation to break down, this is part of giving all perspectives, that, if I'm relatively progressive, that must mean I'm anti-originalist. That must mean I have this set of perspectives on how to do policy and law. And if I'm conservative, that must mean I'm an originalist. And that must mean that these are the outcomes that I'm necessarily wedded to. And I especially think in the criminal justice space, as you highlight so well in your book, and that I think is such an important part of bringing the originalist turn of the Supreme Court to the work we do in the criminal justice classrooms, is to help students understand the founders were very concerned about big government and the use of the criminal justice system. I always count 8 of the Bill of Rights to be focused, if not exclusively, on that concern, at least mostly. And so to help students appreciate that, even if I have a conservative perspective, even if I have a originalist perspective, that may mean different things when it comes to a range of these constitutional issues and also these policy issues than might have been the norms, even a generation ago. And so I think it's just so valuable. It's a different version of giving firsthand experience, but it's also another aspect of where I fear that some of our political and legal silos prevent us from breaking out of some of those molds that, again, your book does such a great job to encourage us to do that. And so thank you. I will say as a last point, I'm hoping that you will get to see some of the reconsideration of these doctrines in your lifetime, in part because I do think if law schools help bring these issues to students and they bring them to the state courts especially, that's the part that I think is often a missing piece of a lot of these equations, probably some bold state court rulings, not just on state constitutional law, but also on federal constitutional law, have the best hope of kind of forcing the Supreme Court's attention to some of these sets of issues. I'm not sure exactly how that should play out, but I do think there could be pathways to kind of quicker reconsideration that, again, your book does a great job helping folks understand the need for that and the path to that. But it may be we're getting old, I suppose. I shouldn't plan for the celebration in our lifetime, but I want to at least imagine it.
Thank you so much for your time today, your insights, and for creating this wonderful book that I hope more people like me, in other words, like more non-lawyers will really read, and hopefully it'll be like a gateway for them to pay greater attention to the justice system and who's making these decisions that we have to follow.
Oh, thank you very much. I did try to write it so that you do not need a law degree. So you have all the relevant legal background is in each chapter so that you could kind of judge for yourself the cases. So it's not, I tried. I did try.
Oh, you did great. You did great.
And did great here as well. Thank you so much.
Oh, thank you. This was fun.
Drugs on the Docket is a production of the Moritz College of Law, Drug Enforcement and Policy Center. This episode is produced by me, Hannah Miller, and Holly Griffin. Doug Berman is our editorial advisor. The music is composed by Joe DeWitt.